The Ministry of Internal Security had ranked the Mombasa Republican Council the second most dangerous group after the Al-Shabaab. But that was until a three-judge bench sitting at the Mombasa High Court, consisting of Justices John Mwera, Mary Kasango and Francis Tuyot, delivered this ruling.
The declaration published in Gazette Notice 12585 by the Minister of State for Provincial Administration and Internal Security that Mombasa Republican Council is an organized criminal group is unconstitutional and is hereby lifted.
And for the avoidance of doubt,
this decision is specific to the ban on MRC. It is a decision on whether or not the proscription of MRC is unconstitutional. It is not a general discussion about the entire Gazette notice which outlawed 32 other groups.
That in effect means that although the same legal notice that outlawed MRC also outlawed other groups like Al-Shabaab, Mungiki, Chinkororo, Sungu, Jeshi la Mzee, Taliban, among others, the rest of the groups remain proscribed. The court session attracted a multitude into the court precincts, a situation that called for heavy security deployment. However, the judges were quick to warn that the decision wasn't a license for MRC to disobey the law.
So if MRC crosses the line, then the state, as always, can invoke the law, including the Prevention of Crimes Act.
Justice Tuyot went on to explain that the court was giving members of MRC the opportunity to fully enjoy their rights, but warned that they must do it through legal means.
A sure way, it is suggested by the court, and perhaps the only way, is for MRC to organize itself and register itself as a political party.
MRC has been pushing for the secession of the coastal region from the Kenyan territory on grounds of historical injustices meted on the locals by successive governments. For that reason, the government had defended its move to proscribe MRC, terming it a threat to national security. The judges in their ruling stated that they were aware that some would interpret their decision as an endorsement to the group's secessionist demands.
To them we say this: secession can only be achieved by far-reaching amendments to the Constitution.
According to the judges, the decision to secede calls for a referendum.
Any secession must be freely given by all Kenyans. It cannot be forced on them. Are we clear?
But after studying the judgment, Attorney General Githu Muigai declared that the government would appeal. Muigai argues that in reaching the decision, the court failed to acknowledge the government's legitimate concerns that any group or organization challenging the constitutional authority and territorial integrity of the Republic of Kenya cannot enjoy protection by the Constitution. Sylvia Chebet, Citizen Live at 9.